Arrested for being nervous? Judge Fletcher just gave the police a reality check. Officer Miller searched a trunk just for fidgeting. A gun was found, but the judge tossed it. His words? I get nervous seeing a spider. That doesn't make me a felon. No probable cause. Case dismissed. Agree with the judge? Type yes and subscribe. In this episode, we will review a series of critical probable cause hearings held in the courtroom of Judge David Flecher. While the badge grants an officer the authority to enforce the law, the robe grants the judge the power to ensure the law is enforced constitutionally. Today, we focus on the judicial check on police overreach. Those moments when a judge stands as the final barrier between a citizen and a wrongful arrest. A probable cause hearing is the first line of defense for the accused. Under Article 15.17 of the Texas Code of Criminal Procedure, an individual must be brought before a judge without unnecessary delay. This isn't just a formality. It is a rigorous review of the facts. If an officer's report relies on hunches rather than specific, articulable facts, the law is clear. Furthermore, under Article 38.23, any evidence obtained through a constitutional violation, such as a stop initiated without reasonable suspicion, is fruit of the poisonous tree and cannot be used. In the cases ahead, we'll see what happens when the court encounters reports that are conclusory rather than factual, and how a judge's commitment to the Constitution can effectively save a person from the machinery of a corrupt or careless arrest. Our first hearing involves a traffic stop that looks routine on paper, but quickly falls apart under judicial scrutiny. On October 12, 2025, defendant Marcus Thorne was charged with possession of a controlled substance following a stop for a failure to maintain a single lane. Mr. Thorne, you're charged with possession. You have the right to remain silent. Judge Fletcher recites the warnings with practiced efficiency before turning to the prosecutor. Okay, let's hear it. Why did we pull him over? The prosecutor reads from the DIMS. Judge, the officer states he observed the defendant's vehicle swerve slightly over the fog line twice within a 1-mile stretch. Upon stopping the vehicle, the officer claimed the defendant appeared unusually nervous and had shifty eyes, leading to a canine sniff and subsequent search. Judge Fletcher leans forward, tapping his pen. Swerve? Did he nearly hit anyone? Was there a danger to traffic? The report just says swerved over the line, Judge. That's exactly what I mean by conclusory. Fletcher sighs. Under the Fourth Amendment, a stop requires reasonable suspicion based on specific facts. Simply touching a line isn't a crime in Texas unless it's done unsafely. And shifty eyes? That's a hunch, not evidence. Because the officer failed to articulate a specific safety hazard, Judge Fletcher finds no probable cause. Case dismissed. Mr. Thorne, watch those lines, but you're free to go. Our second case highlights the fruit of the poisonous tree doctrine, a legal principle that dictates if the source of the evidence is tainted. Anything gained from it is also inadmissible. On November 15, 2025, defendant Elena Gomez was charged with unlawful carrying of a weapon after a roadside search. Ms. Gomez, you're facing up to a year in jail. Judge Fletcher begins. Let's look at the probable cause. Why were we in the trunk? The prosecutor reads. Judge, after a stop for an expired registration, the officer stated he smelled the faint odor of marijuana. Based on that smell, he conducted a search of the entire vehicle. No marijuana was found, but a handgun was located in a locked box in the trunk. Judge Fletcher shakes his head. A faint odor? Was there any smoke? Any drug paraphernalia in plain view? The report doesn't specify, Judge. Just the odor. We've been here before, Fletcher notes firmly. In Texas, while odor can sometimes provide probable cause, it doesn't give an officer a blank check to bypass the Fourth Amendment, especially when the search yields nothing related to that smell. If the initial search for drugs is found to be unreasonable, that gun becomes poison fruit. Under Article 38.23, the judge determines the search was an overreach. I'm finding no probable cause. You can't just go fishing because you have a feeling. Ms. Gomez, be careful with your paperwork, but this charge is dismissed. The final case in today's episode examines what is often called the Resisting trap. This occurs when a citizen is charged with resisting arrest or interference, even when the initial interaction began without a legal basis. On December 2, 2025, defendant Julian Vance was charged with resisting arrest following a pedestrian stop on Buchanan Street. Mr. Vance, you're charged with resisting. You're facing up to a year in jail, Judge Flecher states, reviewing the DIMS. But I'm looking at the underlying reason for the stop. What was the original crime? The prosecutor hesitates. Judge, the officer was patrolling a high-crime area and observed the defendant walking away quickly when he saw the patrol car. The officer attempted to detain him for questioning, and the defendant became belligerent and pulled his arm away. Walking away isn't a crime, even in a high-crime area, Fletcher counters. That's a hunch, not reasonable suspicion. If the detention was unlawful from the jump, how can we have a charge for resisting it? Judge Fletcher emphasizes that under Texas law, the officer must be lawfully discharging a duty. If there's no crime to investigate, you can't force a detention. This looks like an escalation rather than an investigation. I'm finding no probable cause. The judge concludes. Mr. Vance, just remember, even when you're right, stay calm. It's easier to win in here than on the sidewalk. You're free to go. These hearings underscore why the judicial check is the heartbeat of a fair legal system. As we've seen today, the difference between a person losing their liberty and walking home often hinges on a judge's willingness to demand more than just a badge's word. When Judge Fletcher scrutinizes a report for conclusory statements or dismisses evidence as poison fruit, he isn't just following a technicality. He is upholding the Fourth Amendment. A badge grants power, but that power is not absolute. It is bound by the requirement of specific, articulable facts. Whether it's a faint odor, a suspicious walk, or a slight swerve, the law requires evidence that can withstand the light of a courtroom. When judges refuse to rubber stamp flawed arrests, they protect the innocent, hold the state accountable, and reinforce the principle that government power must always be checked by the law. We hope these cases provide a clearer window into how the justice system is designed to function when constitutional safeguards are prioritized. Let us know your thoughts on these rulings in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can continue to foster a more informed society.